Kong's judicial and legal systems are robust and trusted. The city has been and will continue to be a preeminent center for international legal and dispute resolution services, carrying out functions in relation to mediation and arbitration. Among others, the city was recognized as the third most preferred seat of arbitration in the world in 2021, showing international businesses' vote of confidence in the systems.
What underpins dispute resolution in the Hong Kong courts is a very basic principle. That principle is that justice must be done, but it must also be seen to be done. Now, that principle encapsulates two things. The first is that there has to be great fairness in the way the courts treat people. The second thing is that the courts have to be completely open in the way that it deals with people.
While Hong Kong is part of China, the Basic Law, which is the Hong Kong's constitutional document, gives legal effect to the one country and two systems policy. The Basic Law is a very important document in that it guarantees a number of rights. It maintains and retains the common law system, which has been in practice in Hong Kong for more than 170 years. We have an independent judiciary and have a power of final adjudication by the Court of Final Appeal. Hong Kong has the strongest judicial independence. First, we can look at the quality of the judges. The quality of the Hong Kong judges are top class. And before they can get into the judiciary, they have to undergo a number of years in private practice. Only the best are selected to join the judiciary.
Hong Kong has one of the best regarded judiciaries in the world. Judicial independence is very much in our DNA. In practice, it's done every day, in every case, in every court. Our Court of Final Appeal include local eminent judges who had grown up in the common law tradition, as well as non-permanent judges from other common law jurisdictions. These judges are known to be some of the best and most respected judges in the common law world. Their acceptance of appointments to our Court of Final Appeal is a consistent demonstration of their confidence in Hong Kong's judicial independence and their faith in Hong Kong as a dispute resolution center. Hong Kong's government and other public bodies are challenged in court from time to time, and it's not uncommon for them to lose cases before Hong Kong courts via judicial review and other litigation tactics, even in cases that have generated broad public interest. A sound system of appeals underpin the impartial ecosystem as well.
Public officials who act in a corrupt manner or who has committed a crime are subject to criminal investigation and prosecution. Those who are convicted are done so without fear and favor by the Hong Kong courts.
Absolutely. One of the basic tenets of the common law is that all government action has to be within the four corners of the law. If those actions exceed, in fact, the four corners of the law, the court would have jurisdiction to deal with the matter and then direct the government to modify their actions so that they fall within the four corners of the law. Hong Kong is protected by literally hundreds of international treaties and conventions. And Hong Kong, as part of the Basic Law, in fact, abides by in terms of economic relations. Give you an example. Hong Kong is a member of the World Trade Organization. Through the international law, this is then translated into the Basic Law, translated into our local legislation for the protection of human rights. So we have the protection of rights, which is highly universal, at the same time very much part of the common law and very much part of the international law.
Under the Basic Law and the Bill of Rights Ordinance, public and private rights are well protected in Hong Kong. The international covenant to civil and political rights is also applicable. People who choose to do business in Hong Kong will see the same level of private and public rights that they would see in other common law jurisdictions.
That is what I would call alternative dispute resolution. And Hong Kong is a very vital jurisdiction in that, and internationally very well known. And that is because we have adopted the model law. And that model law in fact, is used in many jurisdictions and internationally recognized, which is why the procedure, which is used in alternative dispute resolution, is very much regulated by that.
Aside from litigation, there are other ways to resolve disputes. For example, arbitration and mediation. In terms of arbitration, Hong Kong is the top 3 most preferred seats of arbitration, and Hong Kong is also home to a number of international arbitration institutions. In terms of mediation, we have the mediate first incentive, and the courts have procedural rules which would require litigants to go through mediation before trial. And as to the financial sector, we have the Financial Dispute Resolution Center for smaller disputes, and this is strongly encouraged by Hong Kong financial regulators.